So, Mr. Rosenthal, it is my great pleasure and honor to have the opportunity to talk to you about what has become one of the landmark cases in Delaware jurisprudence, the Caremark case, of course, where you were representing the plaintiffs and kind of the lead.
I was local counsel.
You were local counsel. And I want to talk a little bit about that, because you have been referred to many times as the dean of the Delaware Plaintiffs Bar. What was your role generally, and what were your interactions with the forwarding firms in New York and in other places? You want to give us a little bit of that background and some of the color on your role?
Well, it's very hard to generalize because our relationship with firms varied firm by firm.
Mm-hmm.
But Delaware jurisprudence, I won't say it's a selfish kind of attitude. They insisted, and I won't define who they is, but insisted that cases brought in Delaware be brought by local counsel. You got to have local counsel.
Mm-hmm.
Local counsel has to introduce you to the court, move your admission pro hoc if you're from out of town, and so we were local counsel. In a few cases, we took the lead ourselves, but by and large, we were retained by out-of-town counsel. So our clients were law firms,
Mm-hmm.
basically. I mean, we had a duty to the individual plaintiffs, of course, but nonetheless, we were retained by out-of-town counsel, and we did all the things that we thought were necessary to discharge our responsibilities as local counsel. We made sure that the pleadings followed the Delaware rules and practices. Often we drafted, prepared the pleadings. Often we argued motions before the court.
Mm-hmm.
Occasionally got in on trial work. Just acted in what we believe was the way the court expected us to act as local counsel.
Mm-hmm.
And I'm pleased to say we were never criticized for doing or not doing.
Well, that was going to be my follow-up question. Did you ever have disputes between positions that your forwarding counsel wanted to take and those that you felt were
Constantly.
maybe a bit too aggressive, or
No, not too aggressive. I mean,
or maybe not
we were
aggressive
lawyers.
enough?
Yeah, these were lawyers determining what's the best strategy for a particular litigation. So we certainly debated that with our out-of-town counsel. I'm pleased to say I think they respected our views,
Mm-hmm.
particularly our knowledge of the Delaware courts and the judges. So our views were heard and taken into consideration as
Mm-hmm.
decisions were made as to how to proceed with the litigation.
Mm-hmm.
Not always.
How about in the context of the Caremark case itself? Anything that you remember as
No,
a dispute
no.
in strategy, or everyone was rowing in the same direction?
No. Yeah. My recollection is that on the plaintiff's side, at least, counsel worked together very efficiently, and there were no disputes that I'm aware of. Now, that doesn't mean there weren't disputes.
Mm-hmm. None that you recall, though.
Yeah.
Now, do you recall who you were working with in the Caremark case?
Good Kind and Loie Dannenberg.
Mm-hmm.
They were the co-lead counsel, and most of our work was done directly with representatives of those firms. So don't ask me to remember the names. I remember some.
Yeah. Now, are these folks that you had worked with
Yes.
often in the past?
Oh, yes.
In other
Yeah.
contexts?
Oh, yeah.
And in terms of I imagine they contacted you. Was that your first involvement in this case, or did you hear from the stockholder plaintiff?
No, the stockholder contacted them. They contacted us.
Mm-hmm. And so what was your first interaction? Had you been following, what was going on at Caremark in the press, or?
it's 30 years ago, so I certainly don't remember what I read in the press. If it was something of public notoriety, I'm sure I read about it, but I never. I shouldn't say I never. It was rare that I read something and I said, "My gosh, that would be a real good case." That wasn't my role.
How about the actual stockholders that you dealt with? Did you have much interaction with the actual stockholder plaintiffs?
No, we had very few interaction with the stockholders.
And do you recall generally if they were kind of aggrieved, significant stockholders who felt like they were losing a lot of their own, investments, or were they more just folks who were looking to vindicate, to kind of get justice? Any recollection of generally the type of plaintiff that would bring these suits?
Those, and I don't remember any names, but there were some people that lost a considerable amount of money.
Mm-hmm.
There were some large stockholders who were plaintiffs in shareholder litigation.
Mm-hmm.
I mean, all you have to do is go through the reported opinions and the unreported opinions, and you'll see certain names pop up.
Yeah.
I mean, some of them really thought that management was engaged in corrupt practices or was mismanaging the corporation. They honestly wanted to protect their investment. Others did it out of principle. But it's hard to say what motivated the stockholders to come forward.
Mm-hmm.
Certainly in derivative litigation, the shareholders in those days got nothing out of it. I mean, we didn't have any of the bonus to plaintiffs and all that stuff that I think you have today.
What are the types of factors that you would consider, particularly in Caremark and then maybe more broadly, but factors you would take into account in deciding whether to take on a case? And when the Caremark case came into you, did you think, this sounds like there might be a good prospect here?
Oh gosh, you asked me to go back 30 years and try to recall what the original draft complaint looked like. Phew. But Caremark, we used the word notoriety before. I mean, it was really a prominent example of what was happening in corporate America in those days.
Mm-hmm.
Its prominence was not in the litigation until the Chancellor Allen, handed down his opinion.
Mm-hmm.
Then all of a sudden, because of that opinion, it took great prominence. Yeah.
Elaborate a little bit on what you just said, that there was a view, at least, that maybe there was some of what was happening at Caremark was happening more broadly throughout American corporations.
Well, you had the federal sentencing guidelines, which caused corporate America to sit up and take notice of what they had to do in order to conduct business without fear that they would be hauled before a federal court and sentenced to some very, very draconian punishment.
Mm-hmm.
I mean, the guidelines were very severe. And so in the first instance, companies had to, and their advisors, had to take account of the sanctions that could be imposed for misbehavior under the federal laws. That was one. There was really a triad of concerns, but that was the first one. That's post any prosecution or indictment or grand jury investigation or anything. I mean, corporations really had to beware of what the federal government might do if they were caught red-handed doing something they shouldn't do.
Kickbacks, for example.
Yes, kickbacks. yes. And Caremark, of course, is a kickback case. Some would disagree with that, but that's okay.
I mean, that is
bribery,
the
kickbacks.
word appeared in the opinion.
Yeah.
But I do want to get into, so while some of the misconduct may have occurred, essentially this was a case against the board of directors. And at the time, the controlling precedent was a case called Graham versus Allis-Chalmers, where the Delaware Supreme Court had said that boards of directors, absent some obvious suspicion, have no obligation to ferret out corporate wrongdoing.
To engage in espionage.
To engage in espionage, in language that the Caremark court itself called very colorful. That was the precedent that you were wrestling with. How did you deal with that situation, or how did you, when you're coming up with your philosophy of the case, how do you wrestle with that?
We said there were red flags.
Mm-hmm.
The first, not the first, by I think it was 1991,
Mm-hmm.
the Caremark board should have been on notice that something was amiss, and nonetheless the practices continued. They didn't, at least publicly, they didn't seem to be doing anything, and it seemed to be a case where the board should have exercised espionage at that point if they hadn't before.
Mm-hmm.
So Graham versus Allis-Chalmers, of course, was one of the concerns we had, but that was the way we viewed the espionage question at the time.
You've got Graham versus Allis-Chalmers on the one hand, and the other battle you have to face is a statute that you had a hand in drafting, which is Section 102B7, that exculpates directors for monetary, liability for any breach of the fiduciary duty.
I've heard about it.
Loyalty, and you've certainly heard about it. You're now faced with essentially having to show that these folks acted in bad faith. How do you deal with that? Because Caremark did have a 102B7 provision in its certificate of incorporation. So now, with that in mind, how do you approach the case? Is this now a bad faith case?
Well, putting to one side the definition of bad faith, not acting in good faith, you might think that's synonymous with bad faith. Maybe so, it depends. I won't rehash what we were talking about before. But again, by 1991, the board was on notice that something was amiss, and directors who were exercising good faith, the best interests of the corporation, should have done more than the Caremark board did and permitted the practices to continue. So we alleged.
Mm-hmm.
And
you alleged that it amounted to more than just a failing in their due care.
Oh, yes. Oh, absolutely.
And it bled into
right.
almost a loyalty violation at that point.
Yeah.
Annette, did you take a lot of the directors' depositions?
No, I didn't take any depositions personally.
Mm-hmm. But you read all the transcripts and...
Oh, yes. I probably had a hand in the briefs that the plaintiffs submitted to the court, and I don't think we ever got to a motion to dismiss stage that was actually briefed, that I recall. But I was fully aware, and so were my colleagues, of these problems. We also had demand on directors, so that was the business judgment rule. I mean, we had all sorts of issues that we had to address, at least internally, in deciding to go forward and how we would proceed with the litigation.
All of which, I'm sure, colors your thinking into the decision whether to settle or whether to engage in settlement discussions.
Oh, absolutely, sure.
And those settlement discussions in Caremark and then in your other experiences, are you advising your outside counsel as to strengths and weaknesses in front of the Delaware courts? You want to elaborate on that process a little bit?
Well, I must say, it depends upon the case. It depends upon out-of-town counsel. Some out-of-town counsel were very knowledgeable.
Mm-hmm.
And among others, Lowy Dannenberg and Goodkind had practiced extensively in Delaware, and they studied Delaware law. They had a lot of cases here, so they were conversant with Delaware law and all the cases that I was aware of, so we would have discussions about legal issues, but I had every confidence that they knew what they were doing.
Mm-hmm.
And we sort of worked together to come out to where we came out, but we never thought that Chancellor Allen would come out with how shall I put it, a landmark decision, as you put it.
So the opinion itself was a bit of a surprise.
Oh, yes. Yeah.
What was the general now? And I guess in light of that surprise, was it a pleasant and welcome surprise? And did you think this is a
Well,
new?
we didn't like the fact that he cut the fee, but
Well, I mean, apart from
but I thought the reduction was fairly modest.
I thought the reduction was fairly modest as well.
Yeah. Didn't bother me. It may have bothered some of my colleagues, but it's considering what he said about the case before that, his preface, what was to be expected.
His preface was actually, this is not such a great case, even though it's within the context of this landmark decision that kind of articulates not a new rule but a new precept of common law in some respects. He basically says this wasn't the greatest case ever. Nevertheless, does not cut your fee dramatically, only modestly, as you indicated.
Yeah.
But after this opinion, do you, as a plaintiff side attorney, do you think that you've got a better case going into other situations that are like Caremark?
Well, I think so, but it was really not in that context.
Mm-hmm.
I recall, I think somewhat vividly, after 30 years and in an advanced age, and I could be thinking about another case, but I was at a PLI seminar, I think just a few days after the opinion came out, and all they were talking about was Caremark.
Mm-hmm.
I mean, considering the background of what was happening, the federal sentencing guidelines, that was pre knowledge that the federal government was breathing down your necks. Then you had the post knowledge and the record. So it was really at least three pressures. That was the first, the federal sentencing guidelines. The second was post disclosure of what was happening. It was very clear that the federal government would go easier on corporations that cooperated. This is post-disclosure. So you had the pressure on what do you do in order to satisfy the federals that you're going to put this behind you, and you even paying huge sums of money for in excess of what the corporation might have lost, what the public might have lost. And companies that cooperated with the government, not necessarily to the point of pleading guilty, but they fared well. They were not punished as much for it. For example, Caremark was not barred from doing business with Medicaid and Medicare. So that was the second thing. And then Allen's opinion. And what Allen's opinion did was articulate a standard of conduct that directors, companies and their directors, could follow in order to avoid liability to the corporation and its shareholders for failing to discharge what I will now call the Caremark duties. The pre and post federal involvement in this. And that standard, of course, was that famous phrase, I wrote it down as a matter of fact, sustained and systematic failure to exercise oversight. So even though the chancellor did what we hoped would happen in Delaware, that is essentially overrule. Maybe that's too strong a word.
You know, literally it did not overrule, but I think in spirit, probably not too strong a word.
It certainly did not distinguished.
Yeah.
Went
in a different direction.
And embalmed, if you will. Graham versus Alice Chalmers. Instead of having to engage in the espionage exercise to make sure that nothing happened, you now had a sustained and systematic fiduciary responsibility to exercise oversight. If you did your best on that, you'd be okay. So that's basically what he was telling corporate America, that you can forget about Graham, but don't lose hope, because you may make a mistake once. Maybe, I'm just generalizing, you know, maybe twice, but you know, as long as it's not sustained and systematic failure to exercise oversight for whatever reason, you're not going to be deemed to have violated your fiduciary duties in such a way that you would be exposed to liability. That's basically what he said.
I think part of the idea is that almost, at least my thinking of it has been, a few instances, maybe that's a care violation. Sustained and systemic, at some point that bleeds over into loyalty, disloyal conduct, bad faith conduct, or not in good faith, as you pointed out. It's an interesting opinion. A couple of other things. What type of relationship did you have with the defense counsel, particularly your counterparts here in Delaware? Was there any communication, correspondence that occurred solely between the two Delaware counsels so as to keep things at a more measured tone?
When? At what point in time?
Any point in time throughout your practice, or?
I mean, I had discussions all the time. As I probably was considered by some of the plaintiffs' bar a little too conservative for their liking. I mean, we did have firebrands. Shall remain nameless, although I'm sure that others will immediately grasp whom I'm talking about. And we tried to do what we thought was measured, that is, in the best interest of the shareholders and investors, and therefore the corporation, or vice versa, the companies, so that business can go forward as normal. But if wrongdoing occurred, it would be redressed. So where you draw the line, and there were firebrands that saw wrongdoing under every any how shall I put it, any circumstances. I didn't see it that way, and most of my colleagues didn't see it that way.
Yeah. And I guess my question would be, did you ever have situations where you're on a conference call with these folks and you have a firebrand from outside, maybe shouting down the other side, and then you would call back and say,
not in those days.
I want to dial that back a little bit.
Not in those days. Just before I retired, which was January 2012. So I've been retired 5+ years now. That was starting to happen. And I won't say that was one of the precipitating factors in my retirement, because I had already decided what age I would retire at, and that would happen January 1.
But it made retirement that much more sweet.
Well, yes, absolutely, sure. But it didn't happen back in those days.
That's good.
It's different. It's different now.
Yeah.
So I understand, because I really have I've not been involved in this for several years now.
One question would be, in cases like Caremark and other cases that you handled, if there were disputes or disagreements, between your firm and your forwarding counsel, how were those resolved?
Amicably. how can I say? I mean, we resolved them. We came to agreement as to how we should proceed with the case. We didn't take a vote or anything like that. I mean, it was just, I think we were respected. It's not just me, it's my colleagues at the firm as well. We were respected by out-of-town counsel, and we respected them.
Mm-hmm.
With some exceptions.
Were there some firms that were easier to get along with than others?
None of them were easy. Some of them were really conversant with Delaware law, and we could talk, debate as equals, so that it was a good exchange. Some firms weren't quite as conversant. It was tough getting them to understand why we thought
Mm-hmm.
the case should proceed in a certain direction or something like that. So it depends. And there weren't that many firms involved.
Mm-hmm.
Today, I think there's a proliferation of firms in comparison to the days when I was practicing.
Now, when you started, did you market yourself as plaintiff side firm, and how did you make contact with these forwarding firms?
That's a long story, you know.
Well, we've got some time. If you've got some time.
Oh, gosh. No, shareholder litigation is a fairly new phenomenon. And there were some giants who shall remain nameless, because if I name a few, then I'm overlooking some. And they really started it, largely out of New York. And they did a lot of federal cases. When they actually realized that the law in Delaware was favorable to shareholder litigation, and you know, I'm talking about the 50s,
Mm-hmm.
the 60s. They started coming to Delaware, and we got involved as local counsel. I mean, when I started practicing in 1960. By that time, Irving Morris had developed a relationship with some of these out-of-town counsel, and I joined him, and then we both worked in this field, and you know, it just grew.
Mm-hmm.
There were very few other lawyers who were willing to take cases on a contingency, for example.
Mm-hmm.
And sometimes these cases required an awful lot of work,
Mm-hmm.
a lot of time, money spent, because in a contingent fee case, generally as in the negligence field, the lawyer agreed to pay the expenses of the litigation.
Mm-hmm.
And you know, we were willing to take the risk, and so it grew and grew and grew until ultimately, by the 80s, which is when a lot of this came to a head, you know, we handled most of the cases that were filed in the Court of Chancery.
Mm-hmm. It's interesting. Now, did you talk to these firms in New York? I mean, did you go up and sell yourself as I am a plaintiff side Delaware lawyer, or they just the calls just came to you?
Oh,
and
yeah, no, but we went to New York quite frequently.
Mm-hmm.
I think we used to spend probably a day in New York and elsewhere.
Mm-hmm.
But New York was one of the prominent venue for the plaintiff's bar. There were others in Philadelphia.
Mm-hmm.
But New York was by and large sort of the place where most of the cases were generated.
Mm-hmm. You know, in terms of back to Caremark itself, I think the opinion, as you indicated, was somewhat of a surprise, at least in its final form.
To say the least.
Was there any indication at oral argument? Do you recall the oral argument? And,
Oh, yes,
and whether
yes,
there was
yes.
any indication where Chancellor Allen was heading?
In my view, Allen was very hostile.
Mm-hmm.
And his questioning made it very clear that he wanted to go someplace that we had not expected. And I think the defense team was in the same boat.
Mm-hmm.
And, his questioning led everyone to sit up and take notice that he had his mind on something beside just, what was before him.
Mm-hmm.
Which some, as I said before, would say that's all he should have decided. That wasn't his style.
Well, I guess the only other question I would have is any other thoughts or recollections from Caremark that you would like to share?
No, just that Allen astonished everyone. Bill Allen, just did a magnificent job. Some people would criticize him for not deciding what was precisely before him.
Mm-hmm.
I mean, there are some learned folks who believe that a judge should decide what is before him and not anything else. But Bill Allen was not of that persuasion, and so he realized, I think, that corporate America needed assurance that the directors and officers of Delaware corporations, anyway, would have guidelines that he would give them
Mm-hmm.
for discharging their fiduciary duties in a way that, made business practices available. And that's good for the shareholders, that's good for the management, that's good for the companies.
Mm-hmm.
So it was really, really a very timely and, in my opinion, one of the great decisions that came down, even though most of it is dictum, So.
I think a lot of people would agree with you. Mr. Rosenthal, this has been an absolute pleasure. I really enjoyed hearing your observations. Thank you much, sir.
My pleasure. Thank you.